Yes, Mr. Milford.
Good morning, my lords, my lady. I appear for the appellant. Mr. Short KC and Mr. Margot appear for the respondent claimants. And you should have a single file containing both a core bundle and a very short supplemental bundle,
Yes.
an agreed bundle of authorities, and a couple of extra bits of statutory material on your bench just for completeness that my learned friend and I have
Tell us where to insert them, and we can get them off the desk.
I think perhaps just at the very back of the authorities bundle.
Right. Yes.
My lord, may I begin by summarising the issue? Parliament has decided that claimants who bring certain types of Employment Tribunal claims should engage in early conciliation before a claim is brought, subject to prescribed exemptions. And it has decided that they need to prove that they've engaged in early conciliation. And the way such proof is supplied by regulations is for a claimant to provide an early conciliation certificate number to the Employment Tribunal for checking. And I'll just use the shorthand EC number. Here, claims by multiple claimants have been brought on a single claim form and no exemption from early conciliation is relied on. And the question is whether it is sufficient for such a claim form to contain a single EC number which relates to just one claimant on the form, as the claimants say, or whether the claim form must contain a number or numbers which relate to each claimant.
Yes. Before we dive into the detail, Mr. Milford, can you just tell us, by way of background, have any of the supermarket equal pay claims actually come to trial yet?
Not to my knowledge, my lord. No.
But
they are proceeding.
Going what, 9 years, 10 years?
Different numbers of years for different supermarkets, my lord. And I think that the most advanced, to my knowledge, is Asda, and they are coming to a stage 3 hearing in the relatively short term.
Forgive me, I should know what a stage 3 hearing is, but I don't.
That is the hearing to determine equality of value.
Okay. Right. And again, very roughly, you, Mr. Shaw, may know, how many claimants in all are we talking about? Taking Tesco plus Sainsbury's plus Asda, everybody.
I suspect that Mr. Short will have a better handle on this than I do. I mean, it is many tens of thousands, but I don't know the exact number.
My lord, it's well over 100,000. The claim that is likely to come to a stage 3 hearing first is a smaller claim involving Next, where at the moment the stage 3 hearing is listed for the end of this month. I think the stage 3 hearing in Asda is listed for the end of next year, end of 2024. We haven't got a date for that in Sainsbury's, and I'm not sure any of the other cases are as advanced as either. I use the word advanced in a very technical sense, as advanced as either Asda or Next. Both of those, in neither of those cases has the material factor defence been considered yet, although all of them, I'm pleased to say, have dealt with comparability. So the first of the 3 issues.
I'm sorry, I have to excuse my ignorance. What are the 3 issues?
My lord, they're these. The first is comparability. That is the question of whether a claimant can rely on a particular individual as a comparator. Mm-hmm. That question went to the Supreme Court in Asda, it went to the ECJ in Tesco's, but I think that's now been resolved.
And the answer is yes.
And the answer is yes, they can compare, the shop workers can compare themselves to depot workers. The next question is equal work,
Yes.
whether the claimants are employed on equal work with their comparators.
You mean work of equal value?
Usually, sometimes it's slightly more complicated than that, where you have a male cashier who will compare himself to a female cashier.
They can piggyback on the back of the female.
Yes, it's the piggyback claim. So sometimes it's like work. There's a rated as equivalent issue in Tesco's, which I think is an application for permission to the Court of Appeals has been made. But usually, in these cases, it's work of equal value. If that succeeds, the third issue is whether there is a material factor justifying the difference, because these are all indirect discrimination claims. So it's possible to justify them. That's liability. Then, of course, there's questions of quantum.
And has a stage 2 decision been reached in any of the cases?
There have been stage 2 decisions in Next and in ASDA. Stage 2 decide that the parties draw up job descriptions, setting out what the work of the claimants and comparators is. If there's a dispute as to the contents, the stage 2 hearing determines what the true position is. And so, quite literally, some of the disputes have been tiny as to the number of sandwiches being made over a period. I think it's fair to say everyone who's been involved in these has been astonished by what has happened. We have had job descriptions running into hundreds of pages for relatively straightforward jobs. 3-page descriptions of how a Stanley knife blade is changed. And
All right, but
it's caused...
No need to argue the case.
No.
Just wanted some...
that's not a criticism of Sainsbury's at all, because they've not been involved in that yet. But it's just why things have taken so long.
Right. Thank you, Mr. Milford.
Thank you, my lord. I was just setting out the issue for you.
Yes.
And that issue is whether it's sufficient for the claim form to contain a single number relating to one claimant, or a number or numbers which relate to each claimant. In our submission, the claim form must contain a number or numbers which relate to each claimant, and the Employment Tribunal's reasoning on this was right. And we say that outcome is consistent with and reflects the language of the relevant Employment Tribunal rules, and is the only way in which those rules can sensibly be read with the statutory framework as a whole. And we also say that any other outcome would undermine the obvious purpose of the regime, which is for claimants not only to engage in early conciliation, but to show the tribunal that they've engaged in it. And it would create a disparity between the position for single claims and multiple claims, which in our submission would make no sense. So what I intend to do is, first of all, to take you through the relevant bits of the legal framework, then show you the claim forms and early conciliation certificates for these claimants so that you can see how that works.
Yes.
And then make submissions on the purpose and language of the statutory scheme. So can I start with the legal framework? And you have the enabling provision which creates the structure for the framework, Section 18, capital A of the Employment Tribunals Act 1996, at tab 13 of the authorities bundle, electronic page 239 for IC using hard copies. So the primary requirement to engage with ACAS before instituting relevant proceedings is in section 18A, subsection 1. Relevant proceedings is a term defined in section 18. That's now at the back of your bundle. I don't think it's necessary to turn it up, but just for your record, section 18, subsection 1, subsection E, states that relevant proceedings include proceedings under section 127 of the Equality Act 2010, so equal pay. And the duty is to provide to ACAS prescribed information in the prescribed manner. That information is passed to a conciliation officer under subsection 2, and the officer must then endeavour to promote a settlement between the prospective parties under subsection 3. Under subsection 4, if the conciliation officer concludes that a settlement is not possible, or the prescribed period expires without a settlement being reached, then they must issue a certificate to the prospective claimant. And going forward to subsection 7, that provides a power for tribunal regulations to specify exemptions from the need to engage with ACAS in prescribed cases, including by 7A, cases where the requirement is complied with by another person instituting relevant proceedings relating to the same matter. Then subsection 8 prohibits a person subject to the requirement to engage with ACAS from instituting relevant proceedings without a certificate. And we say, of course, that the requirements under subsections 4 and 8 are of particular relevance here, because they indicate that one obvious purpose of this regime is to require a claimant to show the tribunal that they've engaged with ACAS. So that's the enabling power.
Sorry, just going back to a submission you just made.
Yes.
We're looking at this stage at the Act, not at the regulations
Yes.
made under it.
Yes.
You said one of the purposes of the Act is to ensure that claimant demonstrates to a tribunal they've been through ACAS. But all it actually says, unless I've missed it, is you've got to go through ACAS and you have to have a certificate. It doesn't say you've got to present the certificate to a tribunal in this bit of a legislation. Am I right about that?
You are right. You are right about that, my lord. That is what I say is the obvious inference when you read the Act with the regulations which come under it. But yes, you are right. And indeed, one can think there'd be little point in getting a certificate at all if one wasn't required to show it to someone to prove something. In this case, that you've gone through ACAS.
Well, we will come to the regulations, and I understand entirely that that's your case.
Yes.
But I think one needs to be careful about distinguishing between what Parliament has said is a substantive requirement. You have to have been to ACAS, and you have to have a certificate before you can start proceedings. And what the rules say, which are about the procedure by which you do or don't have to comply with various requirements, because just reading the Act by itself doesn't say anything about when or in what circumstances you need to provide the certificate to anybody. And you might read it and say you have to have a certificate before you issue proceedings. If anybody ever challenges your right to issue proceedings, you produce the certificate to them, if you can, and if you can't, then you get struck out. But I don't read the Act as saying you need to produce your certificate before you start proceedings, or when you start proceedings. You don't get that from the statute.
And I accept that. I mean, the purpose of having a certificate must be to show that you have been through ACAS conciliation. The Act itself doesn't indicate that you would need to show that at the gateway stage where the tribunal looks at it, and that I accept.
Thank you.
So the next thing that I wanted to take you to was the early conciliation regulations, exemptions and rules of procedure regulations, which you have at tab 15, page 255. And at regulation 3, one has the various exemptions from the need to comply with the requirement for early conciliation made under Section 18A. And the relevant one for present purposes is Regulation 3.1a. A person may institute relevant proceedings without complying with the requirement for early conciliation, where A, another person, B, has complied with that requirement in relation to the same dispute, and A wishes to institute proceedings on the same claim form as B. Then going on a page to page 258, Regulation 5 provides for the early conciliation rules of procedure contained within the schedule. And one can see under Rule 1 at the bottom of 258 that a prospective claimant has to present a completed early conciliation form to ACAS in accordance with Rule 2, or telephone ACAS in accordance with Rule 3. Then Rules 2 and 3 set out what a form or a telephone call needs to deal with, needs to contain. Rule 4 has been amended in the version you've got here from December 2021. And the relevant version at the time is at the back of your bundle now. And at the time, one can see that Rule 4 required a prospective claimant to present a separate early conciliation form under Rule 2. So if they were going to go down the writing route, in respect of each respondent, or in the case of a telephone call under Rule 3, to name each prospective respondent. The principle being that conciliation is engaged in separately as regards each respondent. Rule 5 says that ACAS...
I'm getting confused now. The document at page 260 of the bundle, Regulation 4, that's the 2021 version. Where's the old
I'm so
text?
sorry, my lord. The previous version is now at the back of your authorities bundle. It was one of the 2 bits of material that we handed out this morning.
Rather odd layout of the page, but yes, I see.
So sorry, my lord. Does my lord have it?
What is the relevant date? What's the date of presentation of the claim forms?
2016, August, September 2016.
Thank you.
And these regulations that you handed up are the 2014 version, which were, did you say?
This, my lady, these are 2014 regulations.
Which were in force in 2016.
Yes.
You can see that it says version 2 from 20th of April 2014 to 30th of November 2021.
Mm-hmm.
Going back to tab 15 and just picking it up now at page 258. I'm so sorry, 260. Rule 5 at the bottom of the page says that ACAS must make reasonable attempts to contact the prospective claimant, and if, but only if, the prospective claimant consents to ACAS contacting the prospective respondent, ACAS must make reasonable attempts to contact the prospective respondent. So that indicates that the early conciliation process doesn't necessarily involve any contact with the respondent at all, so the respondent may not know that it's going on at the time.
Can I just ask, what is the purpose of making somebody go through an ACAS procedure where they have a veto on whether the respondent is contacted? And if the respondent is not contacted, settlement is obviously not going to be possible, and the process is just a complete waste of time.
Well, my lord, I suspect that what's in the mind of the drafter is that if everyone has to contact ACAS, it is likely that a much higher proportion of claims will be settled. But for some claimants, for instance, a claimant where they feel that there's some sort of intense sensitivity that means that they wouldn't want ACAS to contact the respondent, it's going to be difficult to say to the respondent, I'm considering bringing a claim against you. So the regulations are framed in a way that allows a claimant to tell ACAS that they don't want the respondent to be contacted. I mean, that, as far as one can make out, is what must have been in the mind of the drafter.
I can well understand why it's a good idea that people should go through a conciliation process before issuing proceedings in the tribunal. I don't understand why people should have to contact ACAS and at the same time can say, but I don't want you to contact the other side, so please give me a certificate. It seems to me to be an unnecessary added step, but there we are.
Well, be that as it may, it's common ground in this case that all the claimants did go through conciliation. We're concerned about the paperwork, or digital paperwork, not about whether there was.
That is right. That is right.
Yes. Right.
Rule 7 reflects the framework in section 18A, subsection 4 of the Act. It obliges ACAS to issue a certificate if the conciliation officer either concludes that settlement isn't possible or if the conciliation period expires without settlement being reached. And Rule 8 sets out what an early conciliation certificate must contain. So name and address of the prospective claimant, name and address of the prospective respondent, the date of the early conciliation form presented in accordance with Rule 2, and at 8D, one can see that the certificate will have a unique reference number. And it's worth noting that ACAS's practice is to issue a separate early conciliation certificate in respect of each respondent. And obviously that might well be necessary in any event. For example, because the ACAS officer might consider at a certain stage in the process that settlement was possible with one respondent but not another.
Yes. Is there anything in these rules which contemplates more than one claimant making a joint application for early conciliation at the same time on the same form?
These rules, my lord, are written in terms of using the singular, the claimant and the respondent, but one would need to use the Interpretation Act.
You can't put more than one respondent in the same claim form because Rule 4, as then enforced, says you can't.
You can put more than one respondent in the same claim form, my lord. You can't. You have the conciliation form.
Yeah, sorry, that's what I meant. The early conciliation form. Yes. Rule 4, in the form in which you showed it to us in 2016, if there's more than one prospective respondent, the prospective claimant must present a separate early conciliation form in respect of each respondent. So we know you can only have one respondent per form. It doesn't say at all whether you can have more than one claimant per form.
No, and indeed one can and does have. Well, I'll show you the relevant early conciliation certificates when we come to it, my lord.
Well, we know in practice there were multiple
Yeah.
claimants, but there's nothing in the rules which contemplates multiple claimants on the same early conciliation for?
There is nothing in the rules, and it maybe it's just a question of using the Interpretation Act to say, in this case, singular includes plural, and vice versa.
Okay, thank you.
And then finally, one has Rule 9 on page 262. And that says that when ACAS issues a certificate, it must send a copy to the claimant. And again, if but only if ACAS has had contact with the prospective respondent during the early conciliation period, must send it to the prospective respondent. So that meshes with Rule 5, and it emphasises that the respondent may not actually know anything about early conciliation or receive a certificate.
And does that mean that in practice, although we don't have any reference to multiple claimants, that if there are, in practice, what happens is each of those individuals receives from ACAS the copy of the certificate relates to them?
Yes.
So I know I'm jumping ahead, but if we have these M numbers and presumably schedules of people,
Yes.
then that M-numbered certificate with the schedule will be sent out to each person on the schedule.
So the next things I wanted to take you to was the Employment Tribunal rules, which you have at tab 14.
Before you leave these regulations, you showed us the exemption in 3.1a.
Yes.
You don't need to comply with the requirement for early conciliation, where B's complied with that requirement in relation to the same dispute, and A wishes to institute proceedings on the same claim form as B. Now, I've understood that this exemption has not been relied on. As a matter of fact, were all these claimants on the claim form exempt under 3.1a?
In my submission, no, my lord, they weren't.
Why not? Was it not the same dispute?
It was not the same dispute. I mean, for example, it included both claims by women against male workers in depots and piggyback claims, where men relied upon women. And in my submission, that is not the same dispute. It's a fundamentally different.
Well, I thought we
legal
decided
analysis.
that in Briley, and that male piggyback claimants are not, well, it's not the same set of facts as the rules then said, but mostly women claimants in the same job. It is the same set of facts, and
Yes.
the regulations have been broadened further, haven't they? In 2020.
So I think 2 points on that, my lord. And first of all, and I'll come to it later, I mean, we say that the language, same set of facts and same dispute, is not the same. And although there's a Venn diagram where there'll be things in the middle that are both the same set of facts and the same dispute, there will be things that are the same set of facts that are not the same dispute, and there may also be things that are the same dispute but not the same set of facts. So those two things are not coterminous. But coming back to Briley, in my submission, I mean, the reasons why it's not the same set of facts when you have, for example, a woman who is a baker comparing herself to a depot operative versus a woman who's a customer services operative, a fundamentally different job, that would also, when one thinks about the nature of an equal pay claim, it would also mean it's not the same dispute, because the fundamental thing about the equal pay claim is you are comparing one particular type of job to another, and if it's a different job, fundamentally different job, in my submission, not the same dispute.
That's presumably why the exemption route wasn't relied on. Could have spent the last 6.5 years deciding that rather than the numbers point.
Indeed. Well, I'll come to why this particular dispute has arisen now rather than several years ago in due course, my lord, because actually the reason is that Sainsbury's didn't have the information before it to enable it to know about early conciliation, partly because it hadn't got the early conciliation certificates. But yes, I think my lord is right. I think that must be why the exemption was not relied upon, because it was assumed that actually a piggyback claim was not the same dispute as a claim by customer services assistant against a warehouse operative.
But no doubt you'll take us on when we're looking, and I'm sure we will, at the boxes and the way that it, on the form, the way it happens. You're saying, therefore, I assume, although you'll come to it, that in some cases, multiple cases, one would tick the certificate number, because one would have one, and one would tick the exemption box at the same time.
Well, if one thought that, I mean, it might be that you had a multiple claim form where a group of claimants were exempt on the basis, or considered themselves to be exempt on the basis they all did the same job and they were comparing themselves to
Person with the certificate number.
one of, my lady, in my submission, they'd have a choice. They would have a choice.
But actually, I mean, I'm sorry, I started this hair running, but I'm looking at it again. 3.1 doesn't say anything. I mean, that regulation doesn't, and indeed this entire statutory instrument, as far as I can see, doesn't say anything about what you need to put in your claim form. Again, it's about whether you need to have gone through early conciliation.
Indeed.
And the exemption is an exemption from going through early conciliation. And all these claimants, as you told my lady a little while ago, did go through early conciliation. So, in a sense, the reason why they don't rely on exemption is because they don't need to rely on exemption, because they did in fact comply with the requirement.
Yes, I mean...
They might or might not have been able to rely on an exemption as well. And indeed, where you have a claim form with 10 people on it, some of them might well be able to bring themselves within 3.1a because they might be the same job comparing themselves with the same comparator. But some of them might not be, for reasons that you said.
No, that's right, my lord. And the material about what one has to put in a claim form is in the rules, which I'm just coming to now.
Yes, well, I understand that, but it seems to me there are three levels of legislation. There's what the statute says, there's what these regulations say, which tells you when you can rely on an exemption, and how to go through early conciliation. And then there's what the tribunal rules say, which tells you what you have to put in your claim form. Yeah. I'm sorry, I'm being a bit slow, but I'm getting there.
So I was just about to take you to the rules, which are at tab 14, starting on page 241. If one goes forward to Rule 9, multiple claimants, on page 247, one sees there, and this is the version that was in place at the time. I'll show you the version as subsequently amended in a moment. But at the time, this rule said 2 or more claimants may make their claims on the same claim form if their claims are based on the same set of facts. And where 2 or more claimants wrongly include claims on the same claim form, this shall be treated as an irregularity falling under Rule 6, which my Lord Justice Bean will, of course, be very familiar with from Brierley. And it may be worth noting as well that the principle of waiving an irregularity, that actually applied to the claim forms before you today, my Lord, because for the same reason as in Brierley, claims by piggyback claims and claims by the baker versus the depot operative were not claims based on the same set of facts. It was a question of the irregularity being waived, and it has been waived. So that's how these claims got past the requirements of Rule 9. If I can take you to the version of Rule 9 as amended.
No, I'm sorry. It's my fault. I didn't follow what you just said. These claims have passed and got away with an irregularity.
That's right, my lady, because they include claims that are not based on the same set of facts as found by this court in
Yeah, so okay,
Brierley.
not within 9,
Not within 9.
but they're all on one form.
They're all on one form.
And how did they
there is
that
power in the Employment Tribunal to waive an irregularity under Rule 6.
And that's been
that
waived.
has happened. So that is why these claims have not been found to be non-compliant on the basis of Rule 9.
Can I pick you up on what you said earlier about a Venn diagram? I understand the language of Rule 9, which is about what you can put on the same claim form, is different, because it refers to same facts, from the language of Regulation 3, which is not about what you can put on a claim form, but it's about whether you have to go through ACAS. Can you give me examples of things which are not in the overlapping bit of the diagram? What things would be the same facts but not the same dispute, or the same dispute but not the same facts?
Well, same facts but not the same dispute. Let me give two examples which, in my submission, would meet that. I mean, suppose you had a particular policy of an employer that was said to that was attacked by two different claimants. One of them said that the policy was indirectly discriminatory on the grounds of sex, and another said that the policy was discriminatory on the grounds of race, for example. Depending upon the circumstances, I mean, of the claimants, that might be a dispute based on the same set of facts, but not the same dispute.
Thank you.
Equally, one might have an instance where claimant 1 claimed against just their employer, and claimant 2 claimed against both the employer and an individual employee respondent. And those claims, one could imagine, might be based on the same set of facts, but would not be the same dispute. Looking at it the other way round, where might you have the same dispute but not based on the same set of facts? That is more difficult. And I must confess, I can't instantly see.
It might be what mathematicians call an empty class.
It might be an empty class.
Thank you. But you say it was found in these proceedings that certain of the claims were based on different sets of facts, but that's an irregularity under Rule 6 and is waived under Rule 6, and that dispute's over.
That dispute's over. Yes. It's pure background for our purposes. Yeah. And since we're in Rule 9, it may be more efficient just to also take you to the version of Rule 9 that is now in place as amended, which you have at tab 16 of the authorities. So that's the version as amended from the 8th of October 2020, which now allows a much wider range of claims to be brought in a single claim form. than was the case at the time of the tribunal's decision. So one can see they can make their claims on the same claim form if their claims give rise to common or related issues of fact or law, or if it's otherwise reasonable for their claims to be made on the same claim form. And that is plainly now sets in place a position where many claimants could make their claims on the same claim form but could not benefit from the exemption in Regulation 3.1a because it wouldn't be the same dispute.
And is there any dispute that this doesn't apply to our claim forms because
No, it doesn't, my lord. And I take you to it just as a
I understand.
interpretative point.
It does seem to indicate that departmental policy is to encourage multiple claims, not to discourage them. Because even in Briley, I think the largest claim was 800 or 1,000 or anyway, that sort of claim. And as you pointed out, the amendment gives scope for even larger claims. Yeah. Okay.
Then going back to tab 14 and picking that up at page 248, you have Rule 10. And that says that the tribunal shall reject a claim, and I emphasise that, a claim, not a claim form, if A, it is not made on the prescribed form, B, it does not contain all of the following information, each claimant's name, each claimant's address, each respondent's name, each respondent's address, or C, it does not contain one of the following: an early conciliation number, confirmation that the claim does not institute any relevant proceedings, or confirmation that one of the early conciliation exemptions applies. So that is obviously the critical rule for present purposes, and it works alongside Rule 12, which both sides accept is complementary to it and should be interpreted consistently with it. And that's at page 251 in the version that it took at the time of the tribunal's decision. And that says...
Before we look at that, we can see from the print at 248, the version of 10.1c, which is the current version, was brought into force in 2014. Do we know what the previous version said?
My lord, I don't think from recollection that there's anything material in the difference between the two, but I can't instantly remember what the previous version said, and I can have that looked at over lunch.
Mr. Shaw.
Yeah, my lord, if I can help, I don't think there was a previous version. The previous version just referred to 10.1a and b. So the missing words, I think, were "and" or was "and" at the end of paragraph A. It's not made on a prescribed form and doesn't have the information.
Oh, I see.
So EC was introduced into the rules.
Is that, so that was introduced April 2014, is that when the relevant provisions of the Act came into force?
Yeah.
Sorry.
No.
Yeah, thank you.
And as one of you, or both of you, have pointed out, 10.1c is misquoted in the Employment Law Handbook.
Rule 12 is at page 251. In the version it took at the time of the tribunal's decision, one has the staff of the tribunal office shall refer a claim to an employment judge, claim form to an employment judge, if they consider that the claim or part of it may be, and then the relevant paragraphs for our purposes, are C, E, and F. C, one which institutes relevant proceedings and is made on a claim form that does not contain either an early conciliation number or confirmation that one of the early conciliation exemptions applies. E, one which institutes relevant proceedings and the name of the claimant on the claim form is not the same as the name of the prospective claimant on the early conciliation certificate to which the early conciliation number relates. Or F, one which institutes relevant proceedings and the name of the respondent on the claim form is not the same as the name of the prospective respondent on the early conciliation certificate to which the number relates.
How are they going to know whether E or F applies without seeing the certificate?
One will not, and
Well, there's no requirement, as I see it in Rule 10, to attach the certificate to your claim form. All the requirement is to put your
Yes.
conciliation number in.
yes.
So how does the
But
staff of a tribunal send it to a judge on the basis that the name is not the same as the name on the certificate if they haven't seen the certificate?
Well, I mean, I don't know precisely how the process works within the tribunal, my lord, but the tribunal itself can check the certificate with ACAS. I mean, that's the premise upon which these rules are drawn up.
Well, is it? I mean, I don't know. It seems to me extraordinarily burdensome that when lead A file a claim with several hundred claimants, is what happens, what is supposed to happen, that somebody at the tribunal, before anything else happens, checks each name against an early conciliation certificate or a number, or finds out something that could take days or weeks of somebody's time, couldn't it? Is that what's supposed to happen?
Well, one is supposed, I mean, it may break down a bit when you are dealing with, let's say, hundreds of claimants in the same claim form. And in fact, this claim form was not referred to the judge under Rule 12 or rejected under Rule 10. The reason why this issue has arisen, as I'll come to later, is because the respondent eventually realised that it was an issue.
Well, if you're right, it's a jurisdiction point. You could take it on the last day of the hearing and say the whole thing's been invalid from start to finish and there's nothing you can do about it. Maybe not after judgment. That's an interesting question. But in fact, you took the point in your pleadings. But if this is, but anyway, going back to what the tribunal staff are supposed to do, as my lord says, it seems rather odd. The claim form certainly doesn't say you must enclose your early conciliation certificate. So what are the tribunal staff supposed to do with the number? Are they supposed to look at it and say, well, that seems plausible, it's got the right number of digits? What else are they supposed to do?
I suspect in practice, my lord, that is actually what happens. That the tribunal staff will say, well, that has, as it were, the correct number of digits. But the premise is that actually one should, if the tribunal staff have got the number, they should be able to correlate that with ACAS.
Can anybody ring up ACAS and say, who does this number refer to?
I'm quite sure they can't, my lord.
Well, how
there
can,
must be a means of...
how can the tribunal staff do it? I mean, you're not showing us any legislation or rules which says if the tribunal staff receive a number, they've got a statutory right to ask ACAS who it relates to.
No, my lord, and I accept that. And there is, on the face of the rules, there is a lack of clarity about how, in practice, the tribunal is going to check that the information has been provided. But there it is. It's a jurisdictional requirement that the information is provided.
And the evidence isn't, for example, that there is a database to which the tribunal staff have access? You have no
I have no basis for
saying that. No.
No, well, can I then put this to you? That looking at Regulation 12, it clearly distinguishes between the case C and case E. Case C is where you haven't got an early certificate number, early conciliation number. Case E is where you do have an early conciliation certificate, but the name is different. Now that seems to me to suggest those are two different things, and that if you have a case where you put an early conciliation number on your form, but it relates to somebody else, it's an E case and not a C case.
That's right, my lord. But the point here, and I'll come to it in due course, is that you've got one claimant with an well, actually slightly more. Let's say 3 out of 40 claimants.
Well, no, let's leave aside the multiple claimants, which is a complication, which certainly in the view of the tribunals gives rise to extra difficulty. Let's look at the simple case. You have a single claimant. His number is in fact R1000, but he puts on the claim form R900. Now, R900 in fact relates to somebody else. If he produces the certificate with his claim form, the tribunal staff concede that it's a case where although the claim form has a number, it's got a different name on it. Now, my question to you is, that looks as if that's an E case and not a C case.
Indeed, my lord.
But if that's right, it means you satisfy the requirement in C by putting a number on it. It doesn't matter whether it's the right number. It doesn't matter whether it relates to you or not. You still put a number on, so it's not within C. It may well be within E because actually the number you've put on is the wrong number and relates to somebody with a different name. It relates to somebody else. But the fact that Rule 12 has split out C and E as being different cases means you can't read C in Rule 12 as meaning one which institutes relevant proceedings and is made on a claim form that does not contain an early conciliation number relating to that claimant, because that's an E case, not a C case. Do you see the point?
I do, and it may be that when you get to Rule 12, the analysis is more naturally E than C. I think coming back to Rule 10, that, well, we'll come to it in due course, but it seems to me that C1, and I'll take you to the relevant case law that also concerns this, that there is a necessary implication that C1 does mean early conciliation.
We're not bound by that, are we?
No,
That's EAT.
No, you're not bound by
It's
it.
caps. Is it caps?
Yes, well, two cases,
Sterling
and Sterling again.
Capsule. Yeah. But without looking at any of the authorities, just looking at the structure of the rules, I think the form of Rule 12 raises a question as to what you do if you have a number, but it's the wrong number. And I think, just looking at the rules, there's at least a case to be said that falls within E and not C. Whereas I think
yes, I mean it may be different for multiple claims, my lord. But
well,
yeah.
I understand that, and that's an added complication.
Yes.
But I think we need to get what the position is with a single claimant straight before we look at the added complication of multiple claimants.
I agree.
And if one looks at it, I mean, I have to say, I agree with my Lord Justice Nugee that if one looks at 12.1c, and you look at it cold, and you're looking at it in relation to an individual claimant, then it seems to me that it causes the office or those who then look at it afterwards much less difficulty, because it's much more of a tick box exercise. Has this got a number, or has it got an exemption? No, it hasn't. It's defective. End of story. Very simple.
In 12, regulation 12, 2A, 2 capital A, 12, 2 capital A, has been there since 2014.
Yes.
And that lays down that a 12.1c defect is a fatal defect, whereas a 12.1e, or for that matter F, defect has the minor error provision, which gives a judge, though not the tribunal staff, a bit of wriggle room. But it's a minor error in relation to a name or address.
Yes. So if one were looking at the circumstance where you had on the assumption that each claim in a claim form needs to have a number that relates to them, if you just don't have any number at all and you have a certificate that doesn't contain the name, that is not a minor error in relation to the name. So, I mean, that would cover the position where, for example, you had, let's say, an employer who had changed its name, and the certificate was in the old name and the claim was in the new name. That might be one example where the saving.
But just sticking as following Lord Justice Nugee's suggestion, which seems to me right, that we should first try to understand this as it applies to a single claim before we look at multiple claims. 12.1c and 2 and 2a, you say the effect is that, as the rules then stood, a minor error in relation to a name or address can be rectified by a judge, but a minor error in relation to the early conciliation number, if there is one, is fatal. Say 1 digit wrong. You've been to ACAS, but the early conciliation number which you put in is the wrong one, because 1 digit is wrong. You say that's absolutely fatal.
And fatal under E rather than C, because in C the number isn't there. But in E it's wrong, but
Yes.
to capital A doesn't go that far.
I mean, it is fatal, my lord. I mean, if to take my Lord Justice Nugee's example, I mean, if your early conciliation number is 1,000 and that's your certificate, but you put in 999 and it is the certificate of Mr. Smith, a totally different person, yes, it is fatal.
Yes.
But it's fatal under E, not under C. Is that your...
Correct.
Yes.
For the single claimant, yes.
Now, what might be the departmental policy in saying that if you get a name or address slightly wrong, that can be rectified. But if you get the early conciliation number slightly wrong, it can't.
The only thing I think, my lord, is that actually there is perhaps there's a rather stronger reason for not wanting people to give numbers that relate to others than there may be for sort of checking whether names on claim forms and names on certificates are precisely the same.
Does seem a bit odd, doesn't it? Okay, anything else from Regulation 12?
Nothing else from Regulation 12, my lord. And then I was just going to take you to a couple of Employment Appeals Tribunal cases concerning the meaning of Rules 10 and 12 and the requirement that they set out in relation to the provision of an early conciliation certificate number. And the first one is Sterling at tab 4 of the authorities.
Can I, just before we do that, I've been looking over the page at Regulation 13. So if it's rejected, either under Rule 10 or Rule 12, notice is sent and the applicant can then apply either saying the decision to reject was wrong or rectifying the defect. And so if you've just got the number wrong, provided you're told quickly that it's rejected, you can then put in the right number. But the problem is, under 13.4, if the judge decides the original rejection was correct, but the defect has been rectified, the claim should be treated as presented on the date that the defect was rectified. What are the time limits for claims like this?
It's within 6 months of the ending of the employment, and there's some very complicated case law about what amounts to the employment and whether and in what circumstances that can comprehend changes in jobs. But for most claimants in these positions who've gone on being employed, the limitation period will not have expired, and the significance is simply the arrears period. For which
how many years arrears do you get?
6.
From the date of presentation of a complaint?
Yes.
Okay.
So if you're told quite quickly, you're moving the goalpost, but hopefully not far.
Yes.
But that's so in equal pay claims that these rules also apply to unfair dismissal claims.
Yes.
And if the unfair dismissal claim is presented shortly before the expiry of the 3-month period and it's rejected, it's then too late. And again, you have to say that the departmental policy must be, if you make a mistake in the digits, the numbers of the EC certificate when you present an unfair dismissal claim, that's a fatal defect, and if it's too late for reconsideration, well, too bad, you've lost. That's what the case is.
One has to recognise that in a case like that, it may have a harsh effect, and indeed, the case law expressly recognises that and takes it on board, and I take it on board too, my lord.
We're dealing with some 103 claimants who are in Category 4 whose claims have been, under the original decision of the employment judge, unable to go forward.
Yes.
Are they all out of time now?
Well, I don't have the exact numbers in my head, my lord, but most of them represented in either or both of 2017 and 2019. So it is actually...
It's a question of arrears.
It's a question of arrears. I'm not sure whether that's the case for all of them, but for most of them.
Well, some people may have changed their jobs, and it's taken so long to get to the position they may have lost the right to present at all. If you're right on this appeal. Yes.
Yes, I'm not sure. Yeah.
Thank you.
So, my lord, I was about to take you to briefly to a couple of Employment Appeals Tribunal cases concerning the meaning of Rules 10 and 12. And
Yes.
The first was Sterling at tab 4. And that was a case where the claimant had submitted a claim form which was rejected by the Employment Tribunal and returned to her on an application of Rule 10 because, as was found by the Employment Tribunal, it didn't contain a valid EC certificate number, and one can see that at paragraph 8 on page 49. And she resubmitted the claim form, but it was then out of time, so it's the point that my Lord Justice Bean is making.
Yes.
And the Employment Tribunal refused to extend time for her unfair dismissal and breach of contract claims on the basis to be reasonably practicable for her to make a claim in time, albeit it extended it on the just and equitable test for discrimination claims. And if one goes forward to paragraph 16, the first issue considered by the Employment Tribunal was whether the tribunal was entitled to infer that the claim form as originally presented didn't contain the correct EC number, and that point is addressed at paragraph 21, and one can see in paragraph 21 the Employment Appeal Tribunal, Justice Langstaff, saying that the tribunal was entitled to infer that the certificate number was missing 2 digits. And then paragraph 22 is the critical one. Once it's accepted that the tribunal was entitled to think that the form did have a couple of digits missing, the question is whether the tribunal was then obliged to reject the form. The wording of Rule 10 was not significantly an issue before me. Where the rule requires an early conciliation number to be set out, it is implicit that that number is an accurate number. The tribunal had found it was not. Once that appeared to be the case, the tribunal was obliged to reject it, and that rejection stands subject only to reconsideration, which was here not asked for. Then at so that's Sterling, and then you have the Caspel case at tab 8. Page 100 of the authorities. And that was a case, and one can see from the head note, where the claimant had contacted ACAS and obtained an early conciliation certificate with his employer's current name at the time of the certificate, and the employer changed its name. And the claimant then submitted various claims, all of which included an early conciliation certificate which related to an entirely different claimant and which claimed against the employer using the employer's new name. And those claims were rejected by the tribunal under Rule 12.1f on the basis that the name of the employer on the early conciliation certificate didn't match the name of the employer on the claim. The claimant then got another certificate with the employer's new name on it and brought a further claim using that new name and the new certificate number, which was accepted. And the EAT held that none of the claims had been correctly instituted because all of them should have been rejected under Rules 10 or 12. The first ones should have been rejected not on the basis of the employer's name, but because the early conciliation certificate number was wrong. It related to a totally different person. and the later one should have been rejected because there couldn't be a second valid EC certificate in respect of the same matter. And the relevant reasoning relates to the rejection of the first claims where you had the wrong number, the wrong EC certificate number, and it starts at page 111. So paragraph 39.
One administrative question. We've been given the EAT transcript version as well as the reported one. Is there because there's some discrepancy, or can we just ignore the second one?
Yeah, my Lord, probably the answer is both. There is a discrepancy. The transcript uses the Butterworth's version, or reproduces the Butterworth's error.
Oh, yes.
But the reported version corrects that.
Right.
That's
Right, we'll use the reported one. Yes, sorry, Mr. Mills.
Yeah.
Which paragraph?
So paragraph 40 is the point, critical point. Points out that in Sterling, Mr. Justice Langstaff had held that where the rule requires an early conciliation number to be set out, it's implicit that the number is an accurate number. Although the appeal tribunal in Sterling was expressly considering the wording of Rule 10, its common ground between the parties that the same must be true of the requirement of Rule 12.1c. Moreover, as was also agreed by the parties before me, the requirement to include an early conciliation number must be the accurate number on the certificate pertaining to the claimant, as opposed to a different certificate relating to an entirely different claimant. So that's the reasoning in Caspel, and I take what my Lord Justice Nugee was saying to me earlier about the interaction between 12.1c and D.
And it's not only not binding on us, but it wasn't argued. It was common.
No, that's right. Exactly. Yes. Then 42 deals with how the matter comes before the judge, and makes the point, which in my submission is plainly right, that Rule 12 of the rule seems to envisage that the input of the judge comes after the claim form has been the subject of a reference, but that's not a necessary requirement. The language of Rule 12.2 obliges the parliament to reject the claim if the judge considers that the paragraphs apply, not said to be limited to a particular stage in the process. It's jurisdictional. And then paragraph 47 and following addresses the question whether this was an irregularity that could be waived by the tribunal under Rule 6, to which the answer given was no, for the reasons set out at paragraphs 57 and 58. So that's the Caspel case.
Do we need to look at why Rule 6 doesn't apply?
I think not. I mean, I don't think that it's suggested by the claimants that Rule 6 could apply here. I mean, there's been no challenge to that reasoning. So, my Lord, though that's the sort of relevant statutory scheme and the authorities, I wonder if I can now just take you to look at the claim forms and the early certificates in this case. So you have three relevant claim forms here. You have the claim form with Mr. Laney as the lead claimant, named claimant on the front, which is at page 231. You've got the Ainsworth claim form at 253 and the Andrews claim form at 273. If one starts with the Delaney claim form, and I think it's probably only necessary to look at that one and the certificates, because the issues are the same, whichever set of claim form and certificate you look at. You've got Maxine Delaney's details as the lead claimant given in box 1.
Sorry,
Then,
which page are we?
Page 231.
Thank you.
So Maxine Delaney's details given in box 1. Then over the page at 2.3, you have the question, do you have an ACAS early conciliation certificate number? The answer given is yes. And if yes, please give it. And one sees there that an R number is provided. R1586, etc., at the top of page 232. And that's a unique number that relates to Miss Delaney alone. And it's worth noting at this point that there's space for details of additional respondents in box 2.5, and box 2.6 asks for details of any ACAS early conciliation certificate number in relation to that respondent, although of course they didn't need to be filled in this case. But one has the same question about ACAS early conciliation certificate number asked in relation to each respondent. So clear indication that if there's more than one respondent, there'd be more than one EC certificate.
But also at the top, under 10.3, under the number, if you haven't got a number, first tick box, another person I'm making the claim with has
Yes,
a number.
indeed.
So that's the...
Yes. Yes.
Mhm.
Yes.
And this R number really was Mr. Laney's.
This R number really was Mr. Laney.
Okay.
Yes.
And there's space under each respondent to give your separate certificate number, or to tick those boxes about
Indeed.
whether you're
Indeed.
under somebody else's umbrella.
Yes, exactly. Then at page 234,
Just before we leave 232, if you leave the 2.3 box blank, and I suppose yes, do you have an ACAS early conciliation certificate number? If you say yes, then you don't get to another person I'm making the claim with has an ACAS early conciliation certificate number. Right. Okay. Sorry. You were going on to 235.
yes, so 234 is the next relevant bit. 3.3, multiple cases. Are you aware that your claim is one with the number of claims against the same employer arising from the same or similar circumstances? If yes, and you know the names of any other claimants, add them here. This will allow us to link your claim to the other related claims. So, and that's been ticked.
We've only got a bit of what appeared in the box. Does anyone know how it went on? This claim is submitted subject to the order from Judge Doyle in Ashford and Sainsbury's for combined proceedings and for transfer to Birmingham Employment Tribunal under multiple. How does that continue?
Yes, so that would have given the number of a multiple. I might rely upon my learned friend, Mr. Short.
It just gave the number of the multiple there and then.
The multiple claim or the
For case management reasons,
Yeah.
the multiple was all of the Sainsbury's claims, for example, that were all combined and heard together.
yes. So, under multiple, is that the end of the?
Under multiple number ABC or whatever,
Oh, I see.
whatever
Right.
the number was.
But that's a claim number, not a conciliation number.
That's right, yes.
Yeah. Yes.
I'm not sure it's a claim number, my lord. It's just a multiple number rather than being the number of a claim. It's a number that the tribunal has chosen to ascribe to a particular matter.
Thank you.
Oh, sorry, I haven't quite understood this. We see that Rule 9 allows more than one claimant to make a claim on the same claim form. But what you've just told us suggests that box 3.1 is not really dealing with a number of claimants making the same claim on the same claim form, but is dealing with linked cases brought by different claim forms. Where is the provision in this claim form which allows you to add more than one claimant to the claim form? Because Rule 9 allows you to do that, and we know that's done because there's a whole schedule of people on this claim form. But where do you find it on the form?
Well, my lord, you don't find it on the form. What you find is in a schedule added to the form, and it's implicit that it can be done. I'll just show you box 15 in a moment, which in my submission does indicate that.
It's very odd because there's an elaborate provision for allowing you to bring claims against more than one respondent. It tells you, each respondent, do you have an ACAS number? And if 3 boxes isn't enough, it tells you how to add more. But it doesn't. You would have thought that was a much less common situation in fact than more than one claimant working for the same employer bringing the same claim on the same form. But it doesn't seem to have any express provision for it at all.
This one comes as 13, box 13, page 240. You've already had the opportunity to add 3 respondents. Are there any more respondents? But that is not claimants. Sorry, that's not a good point.
Is this claim form, this is prescribed, is it, in some way?
I'm so sorry, my lord.
Is it prescribed?
Yes, I mean this is the claim form that you must fill in. But
Because Rule 10
I'm not
says
sure.
you can reject a claim if it's not on the
Yes.
claim form.
Where
do we
it is
find
prescribed,
the rule which says this is the claim form you have to use?
I
think Mr. Short might know.
Yeah, my lord, if I can assist here. It's quite odd. It is, I understand, prescribed by an exchange of emails. I did a case some years ago where the issue was whether a claim form that had been shrunk by a fax machine was still a prescribed form. We were trying to find out where it was prescribed. We were told there was an exchange of emails that we would only be shown if we promised not to show anyone else. That was surprising enough, but the then president of the Appeal Tribunal, Sir Patrick Elias, Mr. Justice Elias as he was, had also made the same inquiries and been given the same answer from the department. So it's prescribed by an exchange
Between the department and
of email, yes, or someone within the department saying this is it, and that's the one they use. There isn't a statutory instrument saying this is the form.
But when you look at Rule 10, the first basis on which you can reject a claim, rather than a claim form, is that it's...
On the form.
Yes.
Well, what... I mean, I'm sure tribunals can do all sorts of informal things, but it seems very odd to make a jurisdictional requirement for claims to be presented, but they have to be on the claim form, prescribed form, and yet you say there has been no form prescribed by statutory instrument.
But not by statutory instrument. As I understand it, the department takes the view that the forms that they use have been prescribed.
How is a claimant, even with the benefit of no doubt expensive legal advice, supposed to discover what the prescribed form is?
Usually, well, one can do it by going to the website. Many claims are presented online or by downloading a form from the website. But that, my lord, yes, it is very difficult to demonstrate that a particular form is prescribed because it's not done by public by statutory instrument. So far as I'm aware, I haven't checked again, but I don't believe any of us will be able to track down a statutory instrument prescribing these forms.
All right. Well, that may not be important, but if at the relevant time a prospective claimant doesn't have to be represented by an experienced firm, went to the departmental website of Bayes or whatever it then was, and typed in ET1, this is what they would get.
Yes, my lord. I think there's a reference number at the very bottom of the first page. It says ET1 claim form 1115. That may well be the November 2015 iteration.
Oh, I see. Okay.
That's the short. It's not really for you, but I'm looking at the Employment Tribunal's Rules of Procedure, paragraph 1, which contains an interpretation provision which says that prescribed form means any appropriate form prescribed by the Secretary of State in accordance with Regulation 12. I don't think we have Regulation 12, but one would normally expect such regulations to say the Secretary of State may prescribe forms by statutory instrument.
Not email.
Would we be given Regulation 12?
Well, no.
Maybe there isn't one.
Yes, it is.
Yeah.
Yes, there is, and it's the ET Constitutional Rules of Procedure Regs 2013 start with a number of regulations which are not often read, and then Schedule 1 is the ET Rules of Procedure themselves. And Regulation 12 is the Secretary of State may prescribe one or more versions of a form which can be used by claimants to start a form, one or more versions, respondents form, and so on. And then 12.2, it is not necessary to use a form prescribed if the proceedings are referred to a tribunal by a court, and so on. The Secretary of State shall publish the prescribed forms in an appropriate manner. Forms have never been prescribed. Well, let's not hold that all employment tribunal litigation from 2013 to the present day has been invalid. At least that's not your case, is it? All right. Let's move on.
But Mr. Milford, were you going to take us then to page 242, section or 15, additional information?
I was.
Yes.
That was exactly the thing I was going to take my lady to next, which says you can provide additional information about your claim in this section. If you're part of a group claim, give the ACAS early conciliation certificate numbers for other people in your group. If they don't have numbers, tell us why. And the box that's filled in simply contains details of the respondent's representative and says at the bottom, all relevant ACAS numbers will be provided directly to the respondent in the register of claimants. Now that, my Lord or Justice Bean will be very familiar with. I mean, that relates to a register drawn up between the parties that sets out long schedule of claimants, when they brought their claims, what their jobs were, etc. I mean, certain pieces of information, possibly their national insurance number as well. One thing about this case, in fact, is that the Register of Claimants did not include an entry for ACAS numbers, although that's what the box suggests. So the reason why the respondents, Sainsbury's, here knows that the claimants have gone through early conciliation, which we accept, is only because it asked the claimants for early conciliation certificates and then went through them in detail, trying to correlate the names on the early conciliation certificates with names of claimants. So that is box 15.
And you said I was familiar with the Register of Claimants. If you mean through Brierley, I've forgotten this, but this is a lead A term. It's not a statutory term.
It's not a statutory term.
It was a schedule or a series of schedules.
Yes. Exactly. Then you have the details of claim, page 243, and paragraph 1 says that details of the claimants are set out in the attached schedule, and one can see from the details of claim that claims are brought by both female and male claimants. And the female claimants say they're doing work of equal value to male employees at distribution centres, see paragraph 4. The male claimants say they're doing like work or work of equal value to female claimants, see paragraph 12. So there's the piggyback claim. And then at the back of the details of claim, you have a schedule of claimants starting on page 247 and ending on page 249. There are 41 altogether making the claim in this claim form.
And you've got ACAS EC date, but not number.
I'm so sorry, my lady.
And you've got the penultimate column,
Yes.
you've got ACAS EC date, but you don't have a number.
Yes. Yes.
And is that the date on which the claimant first involved ACAS, or the date on which ACAS issued a certificate? Yeah.
I'm assuming this is the date on which a certificate is issued, but we're not sure. It's ambiguous.
Date ACAS early conciliation was received.
It may be, but we don't know the answer to that.
But well, I understand it's probably the same date for both, because the contact with ACAS was accompanied by a statement that they didn't want the respondent to be contacted. So the certificate would be issued on the day the contact was made.
You can see that on page 294, where we have a certificate which includes Mrs. Delaney and the date of receipt of the request and the date of issue of the certificate of both 5th of July 2016.
Yes, so my lord, as my lord has indicated, that is the early conciliation certificate for Miss Delaney. And one can see on the first page that the certificate is given an M number, ACAS EC reference number multiple, and then the number starting with M, which is the usual practice for multiple certificates. It says that the prospective claimants are Delaney and others. And then at Annex 1, the claimants to whom the certificate relates are all listed with their own unique R numbers.
No, I'm sorry, I'm not on the right page.
I'm so sorry, my lady. It's 294.
Thank you. And so we have the MU number at the top, and that is for Miss Delaney.
That is for the multiple. So that is for the certificate as a whole, but covering all the people in the annex.
And so would one, as an individual, Miss Delaney, have an R number
Yes.
and an M number as well?
Usually, yes.
Usually.
Usually, the tribunal has actually helpfully set out practice in its judgment, but this is a typical multiple claimant certificate because it has an M number at the top. That's just the name for the number for the certificate, but it also gives R numbers for each individual.
Yes.
Yes.
Is page 295 a sample page?
It's not.
That's the whole of it.
That's the whole of it.
So when you go back to 247, which gives the claimant details, there are different dates given. Some of them are on this certificate dated 5th July 2016, but most of them have got other dates, some before and some later. So you've got a number of different certificates for the claimants on this one claim form. The information that is given at 247 to 249 indicates that all these people have been through ACAS, but it doesn't give the separate numbers, and that's the fatal defect.
It's a fatal defect, we say, for all except the 3 who are also on the certificate with Mr. Delaney. Well, in fact, it's 3 altogether. So if one correlates page 247 with page 295.
So you accept that Mrs. Roberts, Ms. Duff and Ms. Townley are, their claims are valid?
Miss Roberts is not on the claim, so she
Oh,
can
right,
be,
okay.
but Miss Duff and Miss Townley, yes, we do, because that is a...
That's what was decided by the
Exactly.
Employment Tribunal. You tried to appeal it, but you were out of time or something. You couldn't cross appeal.
We couldn't cross appeal.
Yeah. Yes. So they're slightly odd cases because you've only got one ACAS number, which is the R number for Mrs. Delaney. You don't have either the M number or the R numbers for Miss Duff and Miss Townley. But nevertheless, you're stuck with the decision that their claims are valid. Yeah.
Is the multiple, the M number at page 294, that's just the M number for the 4 people on the reverse on page 295?
Yes.
Goodness, this is so complicated. So there are other M numbers, we think, for other batches of varying sizes.
I mean, it depends, of course, how people go through early conciliation, my lord, because you have 41 people on the Delaney claim form, but they could have all contacted ACAS together and all be on a single ACAS certificate, in which case you just give the number from that certificate and it would cover all 41. And just for completeness, my lord, I don't think that I mean, it's exactly the same position with the Andrews and Ainsworth claims and certificates. So I think it's only necessary to look at the Delaney one.
Yes. So if, going back to tab 14, page 247, if this table had a further column after ACAS EC date and a further column for a reference number, whether an M or an R, and that had been given, we wouldn't be here.
We would not be here.
Thank you.
Do I take it we would still be, or maybe we don't need to ask this, we would still be here if the claimants have done what they said they were going to do in box 15 and put the ACAS number, given you the ACAS number in the register of claimants? You'd still say it wasn't on the claim form?
It is jurisdictional, my lord. So,
Well,
But you wouldn't say it had been incorporated by reference? I mean,
well, there might have been that argument. I mean,
Yes.
yes. So,
well, that can't be right, can it? I mean, I haven't really thought about this, but as long as I've been reading or taking part in Employment Tribunal litigation, it's very common practice for the claim form to set out the basic details, and for particulars of the claim, sometimes signed by counsel and solicitors, to be appended to the back of it, in incorporated by reference. I haven't yet heard it said that because the document is served with the form rather than on it, that it's somehow invalid.
Oh no, sorry, my lord. We may be at cross purposes.
Yes.
I am not suggesting that if page 247 had included an ACAS certificate number that we would be here.
No.
That I'm not suggesting. I think that Lord Justice Nugee was putting a slightly different point to me, which is that if an ACAS numbers have been provided directly to respondent in the register of claimants, so not this document, but the administrative document between the parties, and provided at some later stage, whether there might be an argument. My lord, I was going to turn to my submissions now, many of which have been trailed in the discussion that we've been having this morning. My lord, are you happy for me to just plough on rather than...
Yes. Plough
on. So we say the logical place to start is with the evident purpose of the conciliation scheme, on the basis that the court should aim so far as possible to construe the legislation in a way which gives effect to that purpose. If one goes back to section 18A of the Act, the salient features of that section are that any claimant intending to bring relevant proceedings must engage in early conciliation, subject to prescribed exemptions. ACAS must issue them with a certificate showing that they've done so, and they must have that certificate in order to institute proceedings. And we say the obvious basic purpose of that scheme is twofold. The first aspect of it is that prospective claimants should engage in early conciliation where required. And the second part of it is that the Employment Tribunal should be able to check whether early conciliation is required, and if so, whether it's taken place. That is the obvious purpose of the certificate, taking on board my Lord Justice Nugee's point about the stage at which it needs to be presented and so forth. In other words, the scheme of the legislation, we say, gives the tribunal a gatekeeper function. It's required to, as it were, check the claimant's passport to make a claim. And that gatekeeper function cannot depend, we say, upon whether a person is required to engage in early conciliation or not. Because if the Employment Tribunal needs to check whether a person has met early conciliation rules, that is a requirement that necessarily applies to every claimant to the tribunal. The tribunal needs to check to see whether early conciliation is needed in the first place, and if so, whether it's taken place. And that point is reflected in and given a particular form by Rule 10 of the Employment Tribunal rules. That rule requires claimants either to provide an early conciliation number or to confirm that a number is not required. So if an exemption applies or the claim is not relevant proceedings, a claimant needs to say so. See Rule 10.1c. And there's no logical reason in that respect why a claimant in a multiple claim should be in any different position from any other claimant. If in the case of multiple claims, it was only necessary to include one EC number pertaining to one claimant on the claim form, it would, in my submission, wholly undermine the tribunal's gatekeeping function as reflected in Section 18A and Rule 10. It would mean that only one claimant in any multiple claim would need to show anything about early conciliation at all. So there would be no way for the tribunal to check whether claimants, other than the claimant whose early conciliation certificate number was given on the claim form, have been through early conciliation or not. All the other claimants on the form might or might not have engaged in early conciliation and might or might not benefit from an exemption. But they wouldn't need to show any of that at the stage of presenting their claim, and the tribunal would simply need to assume that their claim should be accepted. And in my submission, that would be an odd and anomalous position, and it would be clearly inconsistent with the gatekeeping purpose of the scheme. And there's no basic reason of principle, we say, why a claimant in a multiple claim can ignore procedural requirements that apply to a claimant making a single claim. The need for good order, the need for compliance with the rules is no less in a multiple claim than it is in a single claim. And that basic underlying purpose, we say, supports Sainsbury's interpretation of Rules 10 and 12 as requiring an EC certificate number or numbers which relate to all the claimants on the claim form if no exemption is relied upon. Now, the claimant's essential riposte to that is at paragraphs 62 to 63 of their skeleton. It'll just be worth turning it up at page 82 of the bundle. Because they say where a number of claimants use the same claim form, it would be OTOs for the form to contain anything other than one early conciliation certificate number, because the other claimants will satisfy the multiple claimant exemption. And they say one needs to look at the question of purpose in that light. And that argument would only be right if the tribunal was entitled to assume that the multiple claimant exemption applied just because claims were made in the same claim form. So it would only be right if claims made on the same claim form inevitably benefited from the multiple claimant exemption. And we say that there are 4 independent reasons why that approach to the purpose of the legislation cannot be correct. The first is the express terms of Rule 10. And Rule 10 is directly contrary to any suggestion that the tribunal is entitled simply to assume that the multiple claimant exemption applies. It specifically provides that a claimant must state in their claim form if an exemption from early conciliation applies. See Rule 10.1c, tab 14, Authorities, page 248. There's no carve-out there for the multiple claimant exemption. And neither the Employment Tribunal rules nor the exemption regulations suggests that there's some special and unique rule applying to the multiple claimant exemption, which means that claimants don't need to state whether it applies. So Rule 10.1c, we say, is an absolute answer in itself to the claimant's argument that giving weight to the multiple claimant exemption means ignoring the fact that claimants in a multiple claim form have neither provided an early conciliation number relating to them, nor explained why they are exempt from early conciliation, if indeed they are.
Ah, yes, but you've changed the wording, haven't you? If it said it does not contain one of the following information, 1, an early conciliation number relating to each claimant separately, or something like that, then Mr. Shaw would have no case. You're assuming that an early conciliation number means for each claimant.
I am, my lord, and in my submission that is entirely consistent with the language of the rules, and I'll come to that in due course. So that was the first point I wanted to make on purpose, by way of response to what the claimants say. Secondly, we say the claimant's suggestion that the multiple claimant exemption will always be engaged when claims are properly made on the same claim form is wrong on the face of the legislation. And that's simply because the statutory tests for the multiple claimant exemption and for including claims in the same claim form are and have always been different. The multiple claimant exemption, as we've seen, applies where another person has complied with early conciliation in relation to the same dispute. And by contrast, under Rule 9 of the Employment Tribunal rules, at the time of these claims, claimants were permitted to include their claims on the same claim form if they were based on the same set of facts. And I addressed earlier why those two things are not coterminous. Now, it would have been easy enough to use the same words in Rule 9 and Regulation 3.1a if it had been the intention to ensure that they were precisely coterminous. Both rules could either have used the word same dispute or both could have used the word same set of facts. That wasn't done. One must assume that the difference in language was deliberate. And I've given earlier to my Lord Justice Nugee examples, and no doubt there will be other examples one could think of, where claims are based on the same set of facts but do not amount to the same dispute. So that's point 2. The third reason why we say the claimant's approach can't be right is related to the second, and is this. The fact that claims which can't benefit from the multiple claimant exemption can properly be brought in a single claim form is now still clearer from the legislative scheme than it was at the time these claims were brought. And you've seen the new version of Rule 9 of the Employment Tribunal rules, tab 16 of the authorities, which now allows a much wider range of claims to be brought in the same claim form, plainly going far beyond the same dispute. And if the test for the exemption and the test for including claims in the same claim form were intended to be coterminous, one would have expected Regulation 3.1a of the exemption regulations to be amended at the same time as Rule 9, so that it marched in lockstep, but that it wasn't. That didn't happen. And the fourth point is that the claimants themselves have never previously contended, at least until now, that their claims all amount to the same dispute, so that the multiple claimant exemption would in substance apply to them without distinction. One knows from both the Employment Tribunal and EAT's judgment that none of the claimants were relying on an exemption. And if they had done, in my submission, they were clearly not entitled to, and you have my point on that, for example, a piggyback claim is not the same dispute as a comparison between a customer services assistant, female customer services assistant, and a male depot operative. So those are the answers, we say, to the claimant's main point on purpose as we perceive it. And they explain why providing more information in a multiple claimant claim than just one early conciliation number relating to one claimant is not, as the claimants would have it, unnecessary information. And I should make one final point on purpose before moving on to the language of the rules. It's not the case, as the claimants assert, that Sainsbury's approach necessarily creates any great burden for claimants in a multiple claim form. First of all, if the claimants were entitled to benefit from a multiple claimant exemption, they could simply have stated in box 15 that the exemption applied to listed claimants. Alternatively, all that would be required would be the provision of a single early conciliation number from an early conciliation certificate in which any of the claimants were named, assuming that they could all be covered by it. So if they went through early conciliation together, it would just be one number from that conciliation certificate.
So you're saying when we look back at the schedule, there were a variety of dates, and the date which is for Miss Delaney and the people in that on that page, the other three people, was the 5th of July. If one looks back at the schedule, yes. And there would be other numbers which would be shared by others whose dates fitted on
yes.
in the date column.
And any number from each one of those different certificates.
So then I can't remember how many different dates there were, but there weren't that many. And you'd say, therefore, they just needed a certificate number for each of those groups of people for the different dates.
That's right, and that's a necessary conclusion from what the tribunal has found about M and R numbers. And indeed, I mean, if the easiest group of claimants is just to all go through conciliation together and then all bring a claim on the same claim form, in which case you just give one conciliation number and that covers them all. So it is not, we say, the case that where you have, particularly where you have a sort of highly sophisticated claimant representatives very well used to multiple equal pay claims, that this regime creates any great burden. It need not do so. So those are our points on purpose. Let me turn to the language of the rules, because in my submission, the language of both Rules 10 and 12 goes together with their evident purpose and also supports Sainsbury's case. So I'll start with Rule 10, and both parties agree here that Rule 10 is in essence the primary rule, because if Sainsbury's is right, there's been a failure to provide the minimum information required by that rule. So turning it up at page 248 of the authorities, the Claimants and Employment Appeals Tribunal say it's significant that the rule refers to each claimant and each respondent, but to an early conciliation number, and that's, of course, the basis upon which the EAT found against Sainsbury's. We say, actually, the plain language of Rule 10 supports the respondent, Sainsbury's. The claimant's case depends on a contention that the references to each claimant's name and each respondent's name and to an early conciliation number relate to what must be contained in a claim form for it not to be rejected. And that is not what the language says. On the clear wording of Rule 10.1, those references concern the information that must be in a claim, not a claim form. And the use of the word claim, rather than the phrase claim form, is clearly deliberate. For instance, under Rule 10.1a, it would make no sense to refer to the rejection of a claim form in that context. The tribunal shall reject a claim if it's not made on a prescribed form. And once it's appreciated that the wording of Rule 10 advisedly refers to a claim, and not a claim form, in my submission, the literal language of Rule 10 supports Sainsbury's case. The rule states on its face that a claim, not a claim form, must be rejected if it does not contain an early conciliation number or confirmation that an exemption applies. And the natural meaning of that language is that where you have a number of claims brought in a single claim form, each claim needs to contain an early conciliation number. And as per Caspel, in my submission, that obviously means an accurate EC number which relates to the particular claim.
I'm
Also-
sorry, I don't understand that point. 10.1a, it means it, the claim, is not made on a prescribed form. B, it, seems to me, at any rate, to mean the form. What else could contain prescribed information other than the paper or nowadays digital document?
Well, my lord, a claim is the information in respect of a particular claim that is made on a claim form.
So your submission is that it in B means a claim, not a claim
It
form.
means a claim.
Two people, we know they can do this, basing themselves on the same facts, join into one claim form. How many claims are there? One or two?
There are two, but you can also have a claim that is made by two claimants.
Sorry, I haven't understood that. How can you have a claim made by two claimants if you've just said that normally
Well,
where you have two claimants joining together, there are two claims?
my lord, perhaps I should strip it back.
Suppose Mrs. Brearley and Miss Duff and Miss Townley were the only people named on the claim form. Have they brought three claims or have they brought one?
They have brought three claims, my
They've
lord.
brought three claims. And what does
They've
each
brought
claim
three
need to identify?
Each of those claims needs to identify the information set out in the rule, 10.1a, 1b and 1c.
That seems a bit odd because B1 refers to each claimant's name.
Yes.
That suggests that you're looking in a multiple claim form at it referring to the claim brought by everybody together.
Well, my lord, it may be unusual, but one could have a claim that is brought by two claimants. For example, claimants who are both parties to a contract.
They've each got their own claims. It's not a joint claim in the sense of like a joint tenancy of land that has to be severed. Two people who are both employed, whether under one contract or two contracts, have their own claims, which they can settle separately and so on. I would have thought that each claimant had their own claim, and if that's right, the it in 10.1b, as my lord said, must mean the claim form, because it can't mean the claim, because you couldn't have a claim which had more than one claimant.
In which case, my lord, it is peculiar. I mean, if that were right, then the drafting would be peculiarly inapt, because when you have the governing words, the tribunal shall reject a claim if, and then A, not made on a prescribed, it is not made on a prescribed form, B, it does not contain all of the following information. It, as a matter of obvious language, is apt to refer back to the claim, the thing that is governing both A, B, and C.
I understand it entirely as a matter of grammar, but it's not unknown for the drafters of these regulations to be inaccurate when it comes to grammar. But I have a difficulty with the notion that you can require a claim to set out each claimant's name, where actually what you're doing is looking at the claim as opposed to what's in the claim form. I would be tempted, like my lord, to read 10.1a and b together as saying there are two grounds. Originally, these were the only two grounds for rejecting what's put into the tribunal. One is it's not on a claim form, as prescribed, and the other is, if it is on a claim form as prescribed, it doesn't contain the right information. Because you don't get to B if it's, unless it's on a prescribed form.
Well, indeed, my lord, but I mean, I do come back to my point that actually, as a matter of grammar, it is the claim that needs to contain the prescribed information and not the claim form. So, if it's said against me, as it is, well, even if the purpose is sort of is in your favour, because it would make very little sense for just one early conciliation number relating to one claimant to be enough, where you had 100 claimants on the form. But that purpose cannot be pursued because the literal language of the form is against you. My answer is no. The literal language of the regulation is actually in our favour.
What about little 2? The form shall be returned to the claimant with a notice of rejection, explaining why it has been rejected. What's the it there? As a matter of grammar, I would say it would be the form. Yeah. So, if you're being strictly pedantic on the grammar, little 1 envisaged rejections of a claim, but little 2 envisages rejection of a form.
Well, my lord will appreciate. I mean, my primary point is that actually, as a matter of purpose,
I understand that, but
yes.
you're making a grammatical point.
I'm making a grammatical point because it is precisely on grammar that the Employment Appeals Tribunal found against us. And I say, actually, the grammar is not what the Employment Tribunal thought it was. The tribunal read claim as if it was claim form, and then and purported to apply what it said with the literal words of the regulation, but it wasn't doing that.
It may be that it's difficult to place too much weight on the grammar, but that is your point.
Yes.
Yes, I see. Has this been decided? I should know, but supposing suppose there are 10 claimants on the form, and one claimant's address is missed out. Does that mean all 10 are fatally defective, or just the unlucky claimant number 10?
It's unlucky claimant number 10.
It's unlucky.
Because it is the claim.
Has that been decided, or is that just what everybody assumes must be the case?
It is certainly what we assumed must be the case, and what we
You're not trying to stop.
Must be the case.
You're not trying to stop Mrs. Delaney's claim from going forward.
No.
Just everybody else's.
Everyone else whose name is not on the Delaney certificate.
Well, that is everybody. Oh yes, there's 2 others who are.
Yes. Yeah. So, my lord, that is Rule 10. And coming to Rule 12, we say on a literal reading that also is consistent with Sainsbury's case. And that's because the usual approach in the Interpretation Act, that plural includes singular and vice versa, clearly applies to Rule 12. And to make good that point about singular containing a plural, one turns up Rule 12 at page 251. one has, for example, Rule 12.1f, which states that the staff shall refer a claim form to an employment judge if they consider that the claim or part of it may be F, one which institutes relevant proceedings, and the name of the respondent on the claim form is not the same as the name of the prospective respondent on the early conciliation certificate to which the early conciliation number relates. And of course, many claims are brought every day against multiple respondents, and it can't be suggested that Rule 12.1f should only apply where there's one respondent, or that a claimant only needs to get the name of one respondent right. And in my submission, Rule 12.1e would apply in this case, with the singular including the plural. Because if one replaces the reference to claimant with claimants, 12.1e precisely describes this case. The claims in this case are, in part, ones which institute relevant proceedings, and the names of the claimants on the claim form are not the same as the names of the prospective claimants on the early conciliation certificate to which the early conciliation number relates. It's precisely this case. So in my submission, on its literal wording, Rule 12.1e clearly covers these circumstances. And the claimant's only answer to that is one which depends upon altering the literal language of the rule. They say, page 80 of the bundle, skeleton argument, paragraph 50, that you have to read Rule 12.1e as if in the case of a multiple claim form, the references to the name of the claimant on the claim form should be read as a reference to the name of the lead claimant. But that's not what the rule says, and the rule in my submission works perfectly well if in the case of a claim form which contains the names of more than one claimant, the reference in Rule 12.1e is simply to the claimants and not the claimant. So, under Rule 12, one can naturally see why this falls under 12.1e. I also say, for good measure, that the circumstances would fall within Rule 12.1c as well, albeit taking on board the point that my Lord Justice Nugee made to me. That would not necessarily work in the case of a single claimant, but where you are dealing with multiple claimants, it seems to me that it probably does work, because if one reads the phrase early conciliation number in 12.1c as if it means early conciliation number on the certificate which relates to the claimant, just as a matter of applying the ordinary rules about the implication of necessary words as a process of interpretation, you then have the claim or part of it, claims or part of them, are ones which institute relevant proceedings and are made on a claim form that does not contain either an early conciliation number which relates to them or confirmation that one of the early conciliation exemptions applies. So I do say that in the case of a multiple claim, actually, you could have an engagement of both 12.1c and 12.1e, but I accept that 12.1e is the more natural way to look at this. And in my submission, one can also get at least some assistance on the meaning of the rules from the wording of the claim form on the basis that it's comparable to guidance issued by the department responsible for the rules. It's designed to work with the rules. So the prescribed form prescribed by the Secretary of State. And if one looks at box 15 on the claim form, as we have at page 242, in my submission, that also supports Sainsbury's interpretation of rules 10 and 12. Because it states in clear terms, if you're part of a group claim, give the ACAS early conciliation numbers for other people in your group, or if they don't have numbers, tell us why. And in my submission, that strongly supports the proposition that a single EC number, which need relate to only one claimant in the group, is not sufficient to comply with the rules. Now, what's said against me on that is that box 15 is not mandatory. That's the claimant skeleton, paragraph 74. That submission seems to rely upon the introductory wording, which says you can provide additional information about your claim. And in my submission, that's not a convincing response, because that introductory rubric reflects the fact that depending upon what the claim is, there may be no need for additional information, because the introductory text needs to work for all claims. But there's nothing optional about what's said next. If you're part of a group claim, give the ACAS early conciliation certificate numbers, or if they don't have numbers, tell us why. That's the language of a mandatory requirement. And for those reasons, we say that the language of rules 10 and 12, looked at also in light of the claim form, similarly supports Sainsbury's case. Finally, I
suppose you might also say, although it's not obviously much weight can be placed upon it, it's not in the form itself, but on page 242 it was obvious that it was expected that the other ACAS numbers would be provided.
Yes.
I'm sure you made that point before.
Finally, I'll just briefly address a couple of points about the practicalities of the operation of the rules as made by the Employment Appeals Tribunal and the claimants. And the first is a point made by the Employment Appeal Tribunal at paragraph 40 on page 111. So 111 of the bundle, paragraph 40. And that paragraph makes the point that if no EC number relating to a claimant was provided, it would always be open to a respondent to raise the failure to conciliate at a later stage as a substantive defence to the claim. But in my submission, that point does not offer any support for the claimant's approach to the rules, because there'd be no obvious logic in the drafter having intended to create a position where the tribunal, as gatekeeper, was unable to check whether large numbers of claimants in multiple claims had complied with the conciliation requirement just because a respondent could identify them subsequently. And the underlying assumption here that a respondent would always be in a position to raise the failure to conciliate at a later stage is, we say, in any case, wrong. Because, as we've seen, the early conciliation rules don't entail ACAS needing to contact a respondent at all unless the claimant consents. And there's no obligation upon ACAS to provide the respondent with a certificate.
Well, I follow that, but it's always open for a respondent to say, as you did in your pleadings way back in 2016, well, you said you haven't provided us with a number, but a respondent could say, prove to us that you've been to ACAS.
Yes.
If you're right
Yes.
and it's jurisdictional, you're saying it can be raised at any time. It can be years later.
But if the underlying intention is to avoid delay and save expense, actually raising a matter, being in a position where for multiple claims, the only way of dealing with it might be to raise the matter years later, would not meet what must have been the underlying objective of the rules. And the whole point of Rule 1012 is that actually one shouldn't be in a position of having to raise the matter years later. We were, but the evident intention of the rules is that it's the tribunal that does the checking at an early stage. So, my lord, those are our submissions, unless my lords have, I'll just check with those behind me
Yes.
as well.
Can I just ask, if you're a respondent and you receive one of these multiple claim forms, you can, without the ACAS numbers of everybody, you can presumably immediately write to the claimant's representatives and say, can you please confirm that all these people have been through ACAS and give us copies of the certificates? Is there any difficulty in that? And would the tribunal be in a position to enforce such a request if it was not complied with?
Well, later down the line, presumably you could get a disclosure order from the tribunal which would require the information to be provided. But at an early stage, one would be dependent upon the claimant's voluntary cooperation.
If you were designing a system whereby there was a gatekeeping regarded as essential before the case goes any further, then why not devise a rule which says any ET1 in a case which requires ACAS conciliation must be accompanied by a copy of the certificate. And all the tribunal staff have to do is look at the certificate. Has it got the name Maxine Delaney? And is it an ACAS certificate in proper form?
I agree, my lord. It would have been an easier way of doing it, one might think. And why it wasn't done in that way, I can't readily say. All that I can say is it wasn't done in that way.
Yeah. Okay. All very odd.
My lord, I'm told by those behind me, one of whom sits as an employment judge and therefore knows about this, that actually the tribunal staff always obtain the ACAS certificates. So that is how the check is done, apparently. And it's obviously not something that is contained, set out in the statutory scheme, but that is apparently what happens.
From whom?
From ACAS.
So it would have been immediately apparent that this, under your argument, that this claim was defective.
Should have been. Should have been.
Can I go back to your Interpretation Act point? So, Rule 12, 1C, you read that, or invite us to read that, as meaning that it should have been referred to an employment judge if the claim was one which instituted relevant proceedings and is made on a claim form that does not contain either early conciliation numbers or confirmations that one of the exemptions applies. What you really needed to say is that each claimant's claim on the claim form has its own early conciliation number or confirmation. That's what you really need.
Yes, and I think I need to go back to 12.1 actually, my lord, which says if they consider that the claim or part of it, and one can, in my submission, if you have multiple claims on a claim form, the claims or some of them.
I see.
I think, as my lord was putting to me earlier, actually 12.1e is perhaps the more natural route, but I say it works both ways.
So in a case such as ours, where Mrs. Delaney's name is on the certificate, but somebody else's is not, you'd say that this claim form, part of a claim made by the claim form, namely the one by someone whose number you haven't got, is a claim which institutes relevant proceedings, and the name of that claimant is not the same
Yes.
as the name of the prospective claimant on any early conciliation certificate.
Yes.
That's not really needing to read the singular as including the plural. It's saying that part of a claim, namely that person's claim, the name's not the same as on a certificate.
Yes, actually, if one takes each claim separately, as in the part of, then I take my lord's point. It's not necessary to read the singulars, including the plural.
Yes, I see. Okay, thank you.
Thank you.
Right. Well, that's wonderful timing. We'll break off now and hear from Mr. Short at 2 o'clock.